What makes a treaty legally binding? Who decides if a country is following the rules? In this advanced legal English lesson, we're diving into the powerful world of international treaties, agreements that shape how countries treat people, solve conflicts, and protect rights across borders. You'll learn the legal vocabulary used in international law, discover how UN treaty bodies monitor compliance, and practice advanced grammar like passive structures and conditionals, all through the lens of real human rights treaties. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and practice, join us in our school community. The link is in the description. In today's lesson, you'll learn how treaties work in the international legal system, how countries make promises, what happens when they break them, and what role international bodies play. We'll focus on important vocabulary like binding, ratify, signatory, and reservations. You'll also improve your grammar. We'll use passive voice, which is very common in legal documents, and mixed conditionals to describe cause and effect in treaty obligations. Everything will be explained clearly using real examples from United Nations treaties and international human rights law. What comes to mind when you hear the word treaty? Maybe you imagine presidents or diplomats signing an agreement, promising to protect rights or prevent war. Perhaps you think of the United Nations, monitoring how countries treat refugees, women, or children. Or maybe you have heard the phrase legally binding. But what exactly does that mean? A treaty is much more than a political statement. It's a legal tool full of obligations, rights, procedures, and sometimes even penalties. And when a country signs or ratifies a treaty, it's making a legal commitment on the world stage. Before we move on, let's reflect on three key questions. A treaty becomes legal binding when? Think about what has to happen after it's signed. One reason countries might hesitate to ratify a treaty is maybe they don't agree with all the terms or fear the consequences. When a country violates a treaty, there could be international criticism, legal review, or even political pressure. Keep these in mind, and they'll help you connect the legal vocabulary and grammar to real-world global issues. A signatory is a country or group that has officially signed a treaty, showing that it agrees with the rules and goals written in that document. Let's look at an example. Costa Rica is a signatory to several environmental treaties. This means Costa Rica signed those agreements, maybe about reducing pollution, protecting rainforests, or conserving wildlife, and has committed to doing what the treaty says. Now imagine a big international conference, like the Paris Climate Summit. Leaders from different countries come together. They negotiate, debate, and finally, they sign. That signature doesn't just go on paper, it represents a public promise. Being a signatory means stepping up on the world stage and saying, "We are in, we will follow through." Let's begin with accession, a term used when a country joins a treaty after it was originally signed. It means the country wasn't at the negotiation table, but still wants to become legally bound by the treaty. For example, the country completed accession to the convention in 2009. That tells us the treaty was already in force, and the state chose to join later through the formal process. Picture a country transitioning to democracy. 5 years after a major human rights convention was signed, the new government decides to commit to international standards. They complete accession, sending a strong signal to the world. We are joining this system of law officially. Next is derogation, a legal word that means a country is pausing certain treaty obligations during a national crisis. It doesn't mean they are leaving the treaty, just temporarily stepping back from some rules due to extreme circumstances. An example, the government issued a derogation during the state of emergency. Now imagine a country hit by a natural disaster. public order breaks down, the state needs flexibility, so it officially informs the treaty body that it's derogating, suspending some rights, like public assembly, but only temporarily. This legal mechanism protects both human rights and national security. Reservations are like conditions a country attaches when it joins a treaty. They say, we accept most of this agreement, but we're not bound by this part. For example, the state joined the treaty but entered several reservations. Imagine a government signing a global human rights treaty, but it disagrees with one article on family law. Instead of rejecting the whole treaty, it enters a reservation. That specific clause will not apply to them. This allows broader participation while acknowledging domestic, legal, or cultural limits. Enforcement. Enforcement is about turning promises into action. It's the system that checks whether countries actually do what they agreed to under a treaty. For example, enforcement of human rights treaties can involve international courts or review bodies. Picture a situation where a state systematically violates free speech rights. NGOs submit reports, victims file complaints, and the treaty body holds a hearing. That's enforcement in action, applying legal pressure and oversight to make the treaty real, not just symbolic. Compliance means a country is obeying the rules of a treaty, doing what it promised to do. It's the goal of every treaty system. For example, the committee monitors each country's compliance with the treaty. Think of regular progress reports. Countries submit documents showing what they've done to protect human rights. If the treaties says schools must be inclusive, the committee checks if reforms happen. If not, that country is non-compliant. Monitoring compliance helps build transparency and trust between nations. Finally, depositary, a formal term for the institution that handles paperwork behind a treaty. The depositary keeps track of which country signed, who ratified, and what reservations were made. An example, the UN Secretary General acts as the depositary for many treaties. Imagine a treaty with 150 countries involved. Someone needs to organize it all, store the official documents, receive notifications, and update the status. The depositary acts like the administrative heart of the treaty system. Without it, the legal structure would fall apart. Now we're going to do a word bang challenge. Let's start with a powerful legal word, something countries do when they weren't at the table originally. Picture this. A new country gains independence. It didn't exist when the Environmental Treaty was drafted 20 years ago, but now it wants to commit. So it goes through a formal process, sending documents, making declarations, and joining the treaty community, even though it wasn't there at the beginning. That process is called accession. It's how a country legally becomes a party to an existing treaty. For example, the country completed accession to the convention in 2009. Here's a term you hear in times of crisis. Imagine a state facing violent unrest, protest, danger in the streets. The government declares a national emergency. For a limited time, it suspends certain civil rights like public gatherings or curfews. This isn't breaking the treaty, it's a legal pause allowed in special cases. That's called derogation. When a country suspends part of its obligations temporarily because of extraordinary circumstances. Now, imagine this. A government agrees with most of a treaty, but not everything. When signing, they say, we accept the treaty, except Article 12 about family law. That won't apply to us. This is a formal statement, and it has legal power. It's called a reservation. And reservations allow countries to join while excluding or limiting certain provisions. An example, the state joined the treaty but entered several reservations. Let's imagine a treaty promises equal rights, but one country ignores it. A UN committee sends experts, reviews reports, and holds hearings. The state must explain its actions and may receive strong recommendations or face international pressure. This is how we enforce international law, not through force, but through legal systems, oversight, and accountability. Enforcement of human rights treaties can involve international courts or review bodies. Let's say a country joins a human rights treaty. It passes new laws, protects vulnerable groups, and files detailed progress reports. Everything it promised, it does. That's called compliance. When a country complies, it means it's doing what it agreed to under international law. For example, the committee monitors each country's compliance with the treaty. When a treaty is signed, where do the documents go? Who keeps track of who joined, who made reservations, and who withdrew? That job belongs to the depositary, the official institution that manages the legal record. Often, it's the UN Secretary General, and every treaty needs a trust keeper. The UN Secretary General acts as the depositary for many treaties. In legal English, especially in international law, we often use the passive voice. Why? Because the focus is on the action, not the person or country doing it. We form the passive with be plus the past participle. For example, the treaty was signed in 1995. We don't care who signed it right now. What matters is that it was signed. Another example. Several reservations were submitted by the state. This structure is very common in treaty law when listing actions, signing, submitting, ratifying, without constantly repeating the name of the country or party. So remember, if you want to sound formal and objective, the passive voice is your friend in legal English. Let's talk about a short story from the real world of international law. In 2003, a treaty was signed by 10 countries. That's passive voice. We don't say who signed it because the focus is on the event. The act of signing matters more than the names. Later, it was drafted, was adopted, was submitted. These are all passive constructions, clear, formal, and commonly used in legal reporting. Now notice this. Reservations were made and recommendations were issued. Again, the actions are central. This style keeps the writing neutral and professionally. Finally, one country was found to be in violation. We don't attack the country, we focus on what the facts show. This is exactly how treaty bodies write their reports. Formal, respectful, and based on action, not blame. So the next time you're writing about international law, ask yourself, do I want to highlight the action? Should I use the passive voice to stay objective and formal? In international treaty law, conditionals are essential for expressing consequences, both real and hypothetical. Let's look at the first one. If a country signs the treaty, it will be bound by its terms. This is the first conditional. It describes a real future possibility. It's often used in legal analysis or policy discussions. If a state joins, here's what will happen. Now, a more reflective structure. If they had ratified earlier, they would have gained protection. This is a third conditional. It looks back to something that didn't happen and shows the impact. It's perfect for expressing regret or missed opportunities in treaty implementation. Finally, the mixed conditional. If the language were clear, disputes would have been avoided. This one connects a present issue, the language is unclear, with a past result. Legal disputes already happened. In advanced legal writing, this structure is powerful for explaining errors in drafting or limitations in treaty enforcement. In legal contexts, conditionals help us do more than speak grammatically. They help us think critically. What would have happened if the states had acted differently? What will happen if they act now? What could change based on one key decision? Let's try putting these into practice with some treaty-based stories and scenarios. Let's look at a powerful example from international treaty history, the Genocide Convention. After World War II, the world was shocked by the Holocaust. In response, the Convention on the Prevention and Punishment of the Crime of Genocide was adopted by the United Nations in 1948. Most countries ratified it quickly, but as is custom, not the United States. For decades, U.S. officials were concerned that the convention might be used against the country in international courts. So, although the treaty had been signed, it was not ratified, and without ratification, it wasn't binding. Many lawyers and activists warned if the United States had ratified the Genocide Convention earlier, its global leadership on human rights would have been stronger. That's a mixed conditional, showing how a past decision affected its current reputation. In 1986, nearly 40 years later, the U.S. Senate finally voted to ratify the treaty, but they added reservations, limiting how it would apply inside the country. This is a classic example of accession to a treaty process that had already been active for decades, and how reservations can limit a state's full compliance. Today, enforcement of the convention is still a global challenge, but the U.S. ratification was seen as a necessary step in aligning with international human rights law. This story reminds us if legal action is delayed, justice may also be delayed or denied. Let's move on to some idioms. During the early days of the Paris Agreement, many countries signed on with enthusiasm, but once the ink was dry, the real test began. A mid sized nation, under international scrutiny, struggled to meet its emission targets. NGOs and watchdogs began to report non-compliance. Facing diplomatic pressure, the government tightened its environmental policies, updating its reporting protocols, and began to toe the line. An example, after signing the climate accord, the country had to toe the line with new emissions regulations to avoid sanctions. This idiom reflects the expectation that once a state commits, especially in writing, it must conform precisely to the agreed standards. While reviewing cases under the 1951 Refugee Convention, a legal aid clinic discovered a disturbing pattern. Several asylum seekers, primarily women fleeing gender based violence, had been denied access to hearings. They were not denied deliberately. Instead, their names were misspelled, their files misplaced, or their claims misunderstood. They had fallen through the cracks of a bureaucratic and overburdened system. For example, the treaty aimed to protect stateless persons, but many still fell through the cracks due to administrative failures and poor outreach. This idiom is often used to discuss the hidden casualties of legal systems that lack capacity, coordination, or sometimes even compassion. Let's take the example of a post-conflict country that signs a bilateral treaty to ensure the prosecution of war crimes. On paper, the agreement is comprehensive. It outlines procedures, establishes timelines, and commits to impartial trials. But on the ground, courts remain underfunded, witnesses are intimidated, and political will fades. So, on paper, the transitional justice framework promised accountability, but actual prosecutions were rare and heavily politicized. So, you use this idiom when you're highlighting the difference between legal formality and operational reality. In high level negotiations over nuclear disarmament, both sides express goodwill, at least publicly. But when push comes to shove, nations often prioritize national defense over global consensus. A delegate might walk out, a clause might be rejected last minute, and carefully crafted compromises unravel. The country supported the Non-Proliferation Treaty, but when push came to shove, it refused to allow independent inspections. This idiom captures the moment where diplomacy ends and real interests come to the surface. often revealing the limits of legal agreements. In treaty law, pacta sunt servanda, agreements must be kept, is only meaningful if both parties act in good faith. During negotiations over the law of the sea, coastal states and landlocked states disagreed fiercely over access to marine resources. But progress was possible because both sides engaged in good faith, listening, compromising, and avoiding manipulation. An example: the mediators insisted that all parties submit proposals in good faith, or the process would lose credibility. This idiom is foundational in international legal discourse. It implies not only honesty, but respect for process, for fairness, and mutual trust. Let's finish up with a story. A new environmental treaty was drafted with strong language and broad support. Over 50 nations had already completed accession, and the final text was deposited with the designated depositary in Geneva. On paper, the agreement appeared airtight: strict emission limits, clear timelines, and robust enforcement mechanisms. But within months, several issues began to surface. Some states included reservations that weakened key obligations. Others sought derogations, claiming national emergencies. And while all parties were expected to toe the line, reports showed that compliance was being delayed or ignored in certain regions. As the depositary began compiling updates, it became clear that multiple vulnerable communities had fallen through the cracks. Their protection would have been ensured if enforcement mechanisms had functioned as intended. Meanwhile, when push came to shove, one major state withdrew cooperation entirely, citing internal pressures. The remaining states questioned whether negotiations had truly been conducted in good faith, or whether political motives had overridden legal commitments. This story illustrates the gap that often exists between what is written and what is done. Even when treaties are signed and deposited, if compliance is not enforced, if derogations are granted too easily, and if states fail to act in good faith, then international agreements risk becoming empty promises. If enforcement were properly coordinated, and if legal obligations were upheld without exception, fewer communities would fall through the cracks, and treaty law would function as it was intended. Let's review what you learned today. First, you learned essential vocabulary from the language of treaties, words like accession, compliance, and derogation, which help you speak clearly about international obligations. Then we practice using the passive voice, which is standard in legal writing, especially international law, and especially when describing processes or actions without naming the actor. You also reviewed conditionals, which allow you to express both real and hypothetical outcomes, crucial when analyzing treaty scenarios or legal consequences. And finally, you explored 5 advanced legal idioms like toe the line and fall through the cracks that add depth and clarity to your legal English. These tools help you communicate more precisely and persuasively in legal contexts. If you're ready to take the next step, join our school group for live sessions, expert lessons, and real practice. The link is in the description, and we're here to help you grow.